Namaste. So now let's take up Theory of Relevancy, that is lecture 2 under the Indian Evidence Act module of our Judiciary Preparation online course or online coaching program, you can say. Section 5 embodies 2 rules of evidence. So first and foremost, open your back to section 5 because I'm going to, go to that section very soon. Write this down. No facts other than those having rational probative value should be admitted in evidence. Rational probative value, पिछले lecture में हमने discuss करा ही था, that it allows the court to come to a conclusion, right? Anything that which allows the court to a conclusion or come to a conclusion has rational probative value. So no facts other than those having rational probative value should be admitted in evidence. So let us say Nandini murders Aditya. Hopefully not, but let us say that she does. What happens? कि जी जहाँ पे in the room that she murdered Aditya in, there was a blue colored bed sheet. Who cares? But the knife that was used was a kitchen knife. Now, out of these two, or let us say as I told you पिछले वाले lecture में, let us say that this remote was lying there on the bed. Doesn't matter at all. Does this fact that the remote was lying on the bed, does this fact has any rational probative value in trying to get the court to come to a conclusion? No. So chuck it out. But we have to focus only on the relevant facts because the judicial time is limited, right? And all facts having rational probative value are admissible in evidence unless excluded by a positive rule of evidence, as we discussed in the last lecture. Admissibility presupposes relevancy. So अब relevant आपने चेक कर लिया, फिर उस पर admissibility चेक कर लो कि भैया क्या ये admissible है कि नहीं, because admissible यही सब कुछ तो is regulated by the Indian Evidence Act, right? Chapter 2 of the relevancy of facts. Evidence may be given of facts and issues and relevant facts. Section 5 के अंदर हमें evidence may be given in any suit or proceeding. So this gives you a hint, right? So this is how we break down the section. We're just going to start that procedure. Proceeding of the existence of non-existence of every fact and issue and of such other facts as are hereinafter declared to be relevant and of no others. So the Indian Evidence Act is quite strict. It is saying that evidence may be given in any suit or proceeding of the existence of non-existence of every fact and issue and of such other facts as are hereinafter declared to be relevant. So only relevant के ऊपर काम करेगा. This section shall not enable carry CPC वाली provision. अभी जरा करते हैं. Illustrations as usual are extremely important. A is tried for the murder of B by beating him with a club with the intention of causing his death. At A's trial, the following facts are an issue. Obviously, FIU आज से आप facts and issue को FIU नहीं FIU use करेंगे. A is beating B with the club. A causing B's death by such beating. A's intention to cause B's death. All of these are facts and issue क्योंकि इसी के ऊपर कोर्ट में लड़ाई है कि ये सब हुआ है, अगर हुआ है तो कैसे हुआ है, उसका एविडेंस लेकर आओ, and that evidence is being regulated by the Indian Evidence Act. ठीक है. The essential ingredients of the theory of relevancy is evidence must be given in a suit or a proceeding. They must relate to a fact in issue and relevant facts. So suit or proceeding, suit हमेशा civil में जाएगा, proceeding is civil and criminal of course. Fact and issue is net आप कह सकते हैं matter in controversy. Again, example, clothes while wielding the club in the illustration. It's not the matter in controversy. The matter in controversy is whether that person, whether Mr. A hit the person with the club and whether that was the cause of the death. So those are the things that which the court will be mightily interested in, not what that person was wearing, unless and until that wearing of those very specific clothes did something in murdering. Again, Nandini is murdering Aditya. वही हमने यहाँ पे सारा का सारा अपना example पिछले lecture से भी हम लेकर आ रहे हैं. So यहाँ पे you must think. Lecture 1 से I think this should be clear. The facts definition section 3 में facts means and include anything. वाह. State of things or relation of things capable of being perceived by the senses, sense organs, senses. Any mental condition of which any person is conscious. तो अगर आप ये 3 illustrations देखेंगे, that there are certain objects arranged in a certain order in a certain place is a fact. So I am shooting this on a video is a fact. There are bare acts lying here. There are my books. There is everything. So this, all of this is a fact. That a man heard or saw something is a fact. That I can hear that somebody is walking by. Fact. That a man said certain words is a fact. That you are hearing me right now speak is a fact. That a man, so these three illustrations are basically illustrations of आपका ये जो clause 1 जो है. That a man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or use a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. So these are psychological facts. So let us say that you hold a certain opinion, that a man holds a certain opinion. This is a psychological fact. This is not a physical fact. So clause 1 is talking about physical facts. Clause 2 is about psychological fact. That the man has a certain reputation is a fact. A reputation again intangible cheez hai, right? So this is a psychological fact. So not exactly a physical fact. तो illustration आपने ऐसे divide कर. So direct evidence of physical facts is possible always because it's a physical fact. You can produce direct evidence for that. But in psychological facts, only direct evidence may just not be possible. Because let us say that the person, अब आप guilty mind उसका कैसे prove करेंगे? Because that person will not provide you with direct evidence. वो तो कहेगा ना कि मेरा तो जी मन साफ है. I am, my guilt wasn't there. So therefore, you will need to use circumstantial evidence in that case and presumptions drawn from proved relevant facts. So chain बना के हमें उसके दिमाग का state prove करना पड़ेगा of a psychological fact because direct evidence may just not be possible. Let us say the murder was committed at 2 in the night and then there was no one around. How do you produce direct evidence? पुलिस जहाँ वहाँ पे जाएगी, मौके पे सब कुछ ढूंढेगी, but direct evidence may just not, all direct evidence may just not be possible. So we'll have to look at circumstantial evidence of the entire scene, of that entire crime scene. That is why the police tries to secure the crime scene. क्योंकि circumstantial evidence लेकर आएंगे और कोर्ट में chain बनवाएंगे and link कराएंगे and they will prove it beyond all reasonable doubts that the person that they are charging with that particular offense was actually the one, right? So because if we rely on direct evidence of the person, he will presume innocent state of mind. अब उससे पूछेंगे कि हाँ भाई तुम मतलब तुम्हारे दिमाग में शैतानी या बदमाशी थी, तो वो तो कहेगा नहीं थी. Then how do you prove direct evidence in psychological facts, right? Illustrations देखते हैं. A is accused of murder of B. So at the trial, the following facts may be in issue: that A caused B's death, that A intended to cause B's death. तो यही लड़ाई चलेगी ना कि whether A has caused B's death, whether intention was there, because if intention was missing, तो फिर general exception will come into operation from the IPC. That A had received grave and sudden provocation from B, तो वो आपका murder की exception आ जाएगी, whether it was culpable homicide or not. That A at the time of doing the act which caused B's death was by reason of unsound mind and incapable of knowing his nature, general exception, chapter 4, right, section 76 to 106 of the IPC. So for example, A is charged with murdering B. Before conviction, prosecution will have to prove, first and foremost, B died. Second, case of homicide, not suicide. A causing or A caused B's death. A intended to cause B's death. All of these are facts and issue, that is FIU. Alright, not FU, again, it is FIU, short form में कर लेंगे. तो facts and issue यही होंगे ना, क्योंकि इन्हीं के ऊपर कोर्ट डिसीजन देगा कि अगर ये सब हुआ है तो convict the other party, the other side. Because each is a fact under section 3. So facts and issue के अंदर fact तो है. So each is a fact under section 3. Plus each in connection with others establishes A's liability for murder. If A shows grave and sudden provocation, then well, that is also a fact and issue. Because court has to give a decision on that whether it's satisfied that whether it was a grave and sudden provocation, so that हम culpable homicide पे ले जाएं और murder पे ना जाएं. Because in connection with other facts determines A's liability. Further example, let us say A's unsoundness of mind. So Latin name of facts and issues, factum probandum. Prelims के लिए, please write this down, the legal term, factum probandum. This is that which is to be proved. So facts and issue एक बारी decide हो गए by the court. Only those facts will now need to be proved for the court to come at a conclusion. So FIU is the fact which needs to be asserted or to be denied is a fact and issue. Example, Nandini files a suit against Aditya to recover money due on a promissory note. Alright, so issues of fact will be Did Nandini lend money to Aditya? ये भी तो कोर्ट को बताना पड़ेगा ना कि एक ट्रांजैक्शन कैसे हुई थी. Did Aditya execute the note? What amount must he pay back and ancillary relief that Nandini is entitled to? Suppose the court has answered that Aditya lent money to Nandini, Aditya has executed the note, Aditya is liable to pay the amount with interest. All of these become fact and issue as all will be denied by Aditya and asserted by Nandini कि भाई साहब ये सब हुआ था. So यहाँ पे एक और एग्जाम्पल ले लेते हैं. If there are issues of facts, the answers are facts in issue. So if there are issues of facts, write this line down. The answers are facts in issue. So proof of fact in issue is direct evidence or circumstantial evidence primarily. और पहले हमने इनको क्या क्या में डिवाइड करा था, oral evidence और documentary evidence. अब हम सब टाइप्स में चलेंगे तो master heads will always remain as oral evidence and documentary evidence. Now direct evidence given where? Section 60. Oral evidence must be direct, used in section 60. Nandini is charged with murdering Aditya. एक और example. And well, Anushri, Rashi, Tanya, Karan, Kabir, Shikha, they are called by prosecution as witness. बहुत सारे बंदे बुला लिए. Anushri says that she saw Nandini stab Aditya. Great. Hopefully Nandini never stabs Aditya, but अब क्या करें? फंस गए तो फंस गए. Rashi says that she heard Nandini was stabbing Aditya. Tanya says she saw Nandini running away with a blood-stained knife and blood-stained clothes. Karan says that he saw Nandini when she was washing the blood-stained clothes. Kabir और शिखा का अभी अगले पेज पे देखते हैं. Kabir is a doctor who said that the knife found in Nandini's possession could be used to given wounds found on Aditya. Shikha says she heard from Anushri that she saw Nandini stab Aditya. So she is hearing from Anushri that she is. तो अभी तक clear हुआ? अगर if I need to, hopefully I need not go over it. Anushri ने क्या कहा? She directly saw. See the word that automatically comes on my tongue. She directly saw. Rashi says she heard Aditya that Nandini was stabbing him. Tanya says she saw Nandini again. Saw Nandini direct अपनी आंखों से देखा है. करण कहता है मैंने देखा कि उसने कपड़े धोए जिस पे सारा खून लगा हुआ था, आदित्य का खून. होपफुली अब आदित्य कह रहे मेरे मर्डर ही करा दो, है ना. करण कह रहा है, अच्छा करण की तो बात हो गई. कबीर कह रहा है, कबीर डॉक्टर है कि जो नाइफ जो पुलिस पकड़ रही है नंदिनी के पोजेशन में से, यस दैट कनेक्ट्स टू द वुंड्स दैट आर फाउंड ऑन आदित्य's बॉडी. एंड शिखा कह रही है जी मैंने जो अनुश्री को सुना था कि शी सॉ नंदिनी स्टैब आदित्य. अब ये तो हेयर से है ना, कहीं सुनी बात है. तो अब क्लासिफिकेशन के हिसाब से अगर क्लासिफिकेशन में करूं, अनुश्री के पास डायरेक्ट एविडेंस है, दैट एविडेंस ऑफ द वेरी मैटर इन कंट्रोवर्सी. राशि एंड अदर्स हैव सर्कमस्टेंशियल एविडेंस. इफ द कोर्ट बिलीव्स इट, it will assist the court in drawing an inference about the matter in controversy. So the best evidence Anushri has, rest of them have circumstantial evidence. But अभी कहानी पूरी नहीं हुई इस पे, जरा आगे चलते हैं. But if we go as per section 60, except Shikha, everything, all of them is direct. वो सारा का सारा direct evidence. Anushri saw, Rashi heard, Tanya saw, Karan saw, कबीर डॉक्टर ने अपनी गवाही दी है कि जी yes. So all of this is direct evidence. But Shikha, she heard a fact capable of being seen, but she has only heard about it. This is hearsay evidence, and this is not admissible. Generally speaking, this is not admissible. आपकी कहीं सुनी बात कोर्ट में नहीं आएगी, कोर्ट में एंट्री ही नहीं देगी. So direct evidence is sometimes known as original evidence, and hearsay evidence is also known as indirect evidence, derivative evidence. all आपका prelims का समान है. The principal fact or factum probandi, principal fact का दूसरा नाम Latin नाम factum probandi, has inevitably to be proved indirectly by inferences from factum probans. Factum probans means ये आपका जो factum probans is, this means circumstantial or evidentiary facts. So claim of circumstances is complete, and it should be complete, and there should be no gap. Why? Because in most cases direct evidence is not available. So the principal fact or factum probandi has invariably to be proved indirectly by inferences from factum probans. ये आप जरा मैक्सिम सा ये लिख लीजिए, क्योंकि ज्यादातर आप भाई अब रात को कोई अंधेरे में कोई मर्डर हो गया, कोई वारदात हो गई, अब उस टाइम मौके पे तो कोई था नहीं, डायरेक्ट एविडेंस कितना ही आप ले आएंगे. सो सर्कमस्टेंशियल एविडेंस से आप इन्फ्रेंसेस बनाएंगे कोर्ट में और पूरी चेन लिंक आउट करेंगे. सो क्लेम ऑफ द चेन ऑफ सर्कमस्टांसेस हैज टू बी कंप्लीट, there doesn't have to be any gap, so it proves beyond reasonable doubt to the judge. ठीक है जी. So circumstantial evidence is evidence of circumstances. So sometimes it is also called as presumptive evidence. So Nandini murders Aditya. Now Anushri at trial can either give two sorts of statements. Statement one is saying that she saw Nandini murdering Aditya. She saw it. This is the most direct evidence की कि मैंने इसको मर्डर करते हुए देखा ही था. But she can also give one statement that मतलब either अगर सिनारियो में that she saw Nandini running away from Aditya's corpse with a खून भरा चाकू. लेकिन अब यहाँ पे इस स्टेटमेंट में she didn't say that I actually saw her murdering Aditya. तो ये circumstantial evidence हो गया ना. This will help the court draw an inference कि अच्छा उस टाइम पे भाग कौन रहा था लाश से with a खून भरा चाकू. But Anushri has not seen इस वाले सिनारियो के अंदर. इस वाले में सिनारियो तो this is direct evidence. Statement 2 is circumstantial evidence of the circumstances. So statement 1, this makes a statement about the very fact that the court has to decide whether Nandini stabbed Aditya, obviously in this case, right? And statement 2 is about a circumstance, is a relevant fact if which we believed may convince the court the guilt of Nandini. All right. So therefore direct evidence is about the facts in issue, about the matter in controversy. The circumstantial evidence is about circumstances or of relevant facts from which an inference may be drawn about facts in issue, basically from circumstantial evidence. Some cases can rely solely on circumstantial evidence, so mostly in real life cases circumstantial evidence far outweighs the direct evidence, क्योंकि direct evidence मिलना ही बहुत ज़्यादा कठिन होता है, right? So mostly circumstantial evidence, mostly via reports, witnesses, etc. But the chain is very important. Pointing to the guilt is very very important. All right. So relevant, ये जो relevancy जो है given where section 6 to 55. So now we need to decide what is relevant. So under section 3, relevant is one fact is said to be relevant to another when one is connected with the other in any of the ways referred to the provisions of this act relating to the relevancy of facts. So the facts need to be connected to each other. Now she is seen that Nandini is running away from the corpse with a blood-stained knife. Relevant, right? And relevancy ज़्यादातर defined as section 6 to 55. Total section ही roughly मतलब अच्छा and 167 मतलब basically यहाँ पर आपके पास evidence act की almost 1/3 is deciding whether the fact is relevant or not, so that the court is not burdened with irrelevant facts or stuff that it may not even pay any attention to. Okay. So rules in these sections are the principles on which judges in England have admitted facts into an inquiry as being relevant. Therefore, a fact will be relevant in multiple sections. So Sir James Stephens, once it is relevant under a section, तो basically multiple sections के अंदर facts relevant हो सकते हैं. Once it is relevant under a section, next question is admissibility. तो एक बार relevancy decide हो गई, उसके बाद आप क्या करें? Admissibility. Therefore, admissibility presupposes relevancy. All right. So admissibility, अगर even if it is relevant, it may just not be admissible. यही तो सारा फंडा है Evidence Act. So therefore, facts which are relevant may not be admissible. Facts which are admissible may not be relevant. These are the conclusions that we have drawn. Facts which are relevant may not be admissible. जैसे prohibited communications हैं. Section 122, 123, 126, 127. And facts which are admissible may not be relevant. They are given in 146 to 155, provisions to 156 and 157. अब जैसे 157 जरा एक बारी खोल लीजिए बैराक में और वहाँ पे चलिए. Former statement of witness may be proved to corroborate later testimony as to same fact. In order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. तो एक विटनेस साहब ने एक फॉर्मर स्टेटमेंट दी हुई है, पहले शुरुआत में बोली थी वो बात, तो उसके बाद वी आपको that may be proved to corroborate later testimony कि जी पहले उसको जरा प्रूव करा लो ताकि जो later testimony दी है उसमें it adds weight. अब राम रतन वर्सेस स्टेट ऑफ राजस्थान 1962 सुप्रीम कोर्ट 424, तो यहाँ पे this was the accused that has been convicted of murder and evidence was one primary witness that he murdered and witness 2 was कि I was told immediately post when he saw कि जिन्होंने मर्डर कराया बाय विटनेस 1. तो विटनेस 1 के बाद के तहत पे विटनेस 2 टिका हुआ है. अब क्वेश्चन है कि वेदर विटनेस 2 स्टेटमेंट इज एडमिसिबल. मैं दोबारा बोल देता हूँ अगर नहीं समझ में आया. विटनेस 1 सेज भाई ये राम रतन जी जो है ही इज मर्डर्ड, ठीक है जी. तो एविडेंस ऑफ विटनेस 1 एंड देन विटनेस 2 की स्टेटमेंट थी कि आई वाज टोल्ड इमीडिएटली व्हेन ही मतलब सॉ हिम मर्डरिंग, आई वाज टोल्ड इमीडिएटली बाय विटनेस 1. सो दिस वाज रिलाइड ऑन एज एविडेंस. तो इन्होंने अपील में पूछा कि witness 2 की जो statement है whether it's admissible under 157. So the court held in the absence of any in the absence of a statement by the first witness in court that he told the names of the accused to the latter witness. Supreme Court held essentials of 157 में क्या है? A witness should have given a testimony with respect to some fact, should have made a statement earlier about the same fact at or about the time when the fact took place. If one or two are present, the former statement can be used to corroborate. तो basically इन्होंने क्या कहा था कि जो केस जो हुआ था आपको just telling you ये आपका the missing link. तो basically हुआ क्या था in this very case law. At a later stage in the court, the witness 1 never said that he said anything to witness 2. So basically he was silent. This was not repeated in the court of law. So therefore ये जो W2 की जो statement है whether it was admissible under 157 in the absence of a statement by the first witness in court that he told names of the accused to the latter witness. तो latter witness के ऊपर हम rely तो कर रहे हैं but इन्होंने कभी कोर्ट में बोला नहीं कि I told it to witness number 2. इन्होंने नहीं बोला. ठीक है जी, जब नहीं बोला तो कोई बात नहीं. इन्होंने नहीं बोला तो कोर्ट कह रहा है कि नहीं, we can still use it. Nothing in the section that requires that the statement corroborated by a witness must also say in his testimony in court that he had made that former statement to the witness who is corroborating him. तो ज़रूरी नहीं है just because he hasn't mentioned in court doesn't mean कि आप वो उसको prove नहीं करा सकते. It is no bar. Alright. So facts which may not be relevant, which may be relevant, which may not be relevant, 60-55 are admissible under 157. So facts which may not be relevant नहीं है under 65 आप उनको admit कहाँ कराएंगे under 157. So this is one example of such a scenario, right? तो आपके relevant facts, factum probans और fact that proves. illegally obtained evidence के बारे में बात करें. illegally obtained evidence में अगला lecture इसमें RM Alkani from YouTube attach कर दूंगा. So admissibility usually depends on its relevancy. So usually on this relevance 60-55 or 157. Now whether illegally obtained evidence is admissible or not, कि आप चोरी करके evidence ले आए, अब वो admit होगा कि नहीं. In Kuruma versus R, the Privy Council held, if evidence is admissible, it doesn't matter how it was obtained. Write this down, all right. And यहाँ पे हुआ क्या था in this case law कि एक ये आपके Indian Navy Service के अंदर या आपका बेसिकली जो एक एक्यूज को सर्च कर दिया, नेवी सर्विस बोलिए, एक्यूज को सर्च कर दिया गया था बाय रैंक दैट वाज लेस देन दैट ऑफ एन इंस्पेक्टर पुलिस वाले ने, एंड इट वाज नॉट अलाउड अंडर दोज बैक इन द डे स्टैट्यूट. तो उन्होंने कहा था इट डजंट मैटर हाउ इट वाज ऑब्टेन्ड. अब एविडेंस वैसे टेक्निकली स्पीकिंग दैट पुलिस ऑफिसर कुड नॉट ऑब्टेन, बट इन्होंने he got it in, right? So but caution is needed, so judge has discretion to disallow evidence in Kuruma versus R. This was observed. Now tape recorded conversation का RM Malkani का केस है. I'll just explain it briefly here. If you need to go into the facts, then next lecture is for you. RM Malkani versus State of Maharashtra के अंदर illegally obtained जो tape recording थी, that was admitted and that was held to be res geste. Res geste means things proved. मतलब basically that the bigger picture you can say. So res geste admissible under Section 7 of the Indian Evidence Act, even if Section 25 of the Telegraph Act is contravened. So as long as the evidence is relevant, its admissibility is not hampered by the way it was procured. Alright, so if it is being produced in a court of law, and it doesn't matter how it was produced, whether even if via theft, if it is relevant and if it is admissible, the admissibility won't be barred just because the evidence was taken illegally. This fact you have to remember. So Umesh Kumar versus State of AP के अंदर illegally obtained evidence is no bar to its admissibility if it is relevant, as long as the evidence is genuine and not tempered. अभी ये रफेल वाले केस में भी यही हुआ था. The planes के अंदर those documents from the government were illegally obtained. तो क्वेश्चन उठा था ऑफिशियल सीक्रेट्स एक्ट के तहत अगर आपने ये चोरी वोरी करी है and it's a crime, then how are you admitting those documents as evidence? तो भाई the Supreme Court has said on multiple occasions that illegally obtaining it doesn't really bar the admissibility. Birla Corporation Limited versus Adventist Investments and Holding Limited के अंदर ये कहा गया था that even if documents are obtained by theft, they are still admissible. The Law Commission of India in its 94th report advocated कि जी कोर्ट कोई डिस्क्रिप्शन दो एंड 166A जरा देखना 166A बैराक में इंट्रोड्यूस्ड है कि नहीं है. जस्ट आपको बोल रहा हूँ ताकि थोड़ा काम चलता रहे. whether the court ये आपकी जो whether the court has to have discretion, so they advocated insertion of 166A. It was never inserted as usual, but Law Commission of India की 94th report में they had advocated court's discretion on decide whether the evidence will be admitted or not. ठीक है जी. अब यहाँ पे जो section 5 के अंदर this is rule 1 and of no others. So this is extremely important कि जी evidence may be given in any suit or proceeding of the existence of non-existence of every fact in issue. Existence or होना चाहिए, existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. पहले declare करा हो relevant और उसके बाद हमें बाकी किसी चीज़ का evidence नहीं चाहिए in a court of law. ठीक है जी. Explanation कह रही है कि the section shall not enable any person to give evidence of a fact which is disentitled to be proved by any provision of law for the time being enforced relating to civil procedures. So in case of a conflict between CPC and Indian Evidence Act, the CPC will win. Once we do CPC, we'll come back to this to explain. Now in the next lecture, we are going to go to relevant facts of which evidence may be given. ठीक है जी. इसमें मैं आपको मिलता हूँ in lecture number 3. Alright, take care, bye.